managed assigned, what we're calling a managed assigned counsel defender. California calls it private defender system. Thank you, John D.
Thank you very much. I am very honored to be here. I am not just your guest, I am your admirer. You folks are pioneers. You're doing really marvelous things, and I trust that you're proud of yourselves because this is really a huge undertaking. I am from San Mateo County, California. I'm the chief defender there, and as Brian indicated, I've been the chief defender for 11 years. Before that, for 11 years, a little over 10 years, I was the assistant chief defender, and before that, for 12 years, I was a criminal trial attorney. And as a criminal trial attorney, I did everything from misdemeanors to lead counsel and death penalty cases. I've got a lot of time in the courtroom. But coming from San Mateo County, I'm trying to place it for you so you'll get exactly where we are. We are the county immediately south of the city and county of San Francisco. Their southern border. Sway with me there, okay. Gee, that was a good game last night, huh? Yeah. Their southern border is our northern border. And if you looked at a map of the United States, and if Austin was the center, you would see San Francisco to the far left. That is a geopolitical orientation as well as a geographical orientation. But we're immediately south of them, and I've heard San Francisco described as 47 square miles surrounded by reality. We are part of the reality. Crossing the border from San Francisco into San Mateo County is a life-changing experience for some folks because it's a different orientation. I think that's the reason Jim Bethke invited me here, really. When he came out to visit last year with Norm Lefstein, and they visited our county for a couple of days, interviewed a bunch of people, and I think Jim said, I found a place more conservative than Texas. So I've got to invite him out here. It's a world of difference. Let me illustrate it for you with a story. As the chief defender, obviously, we get cases where we have some complaints, and you go over and you visit a complainant in the jail. And we had a kid who was from San Francisco, and he got arrested in our county, and I forget exactly what it was. It was some sort of a nickel and dime drug case of some sort. I don't remember much. But there is in California a thing called a three-strikes law, and there's all kinds of details and applications of it. But basically, for any felony, you can have your sentence enhanced up to 25 to life. So he came into, as a San Francisco kid, been through the criminal justice system next door for a number of years. And we assigned a lawyer to the case. The lawyer went over and talked to him and gave him the lay of the land, and the guy just went nuts. I mean, he called the State Bar of California complaining he had a dump truck lawyer. This lawyer didn't know what he was talking about. How can you be talking about that kind of a sentence? So I went over to visit him, and he was really upset. By the time I got there, he calmed down a little bit. And he says, you know, Mr. D, he said, I asked the lawyer, I thought maybe I'd get 30 days in the county jail. And he told me I'm going to do 32 months in state prison. I said, young man, you crossed the border. He said, you know, sir, I understand. I am out of bounds. And so it is a different place than San Francisco. But let me give you a little bit of an overview of the private defender program. We are a county of about 730,000 people. It is largely urban. It's an interesting place geographically if you're ever there. It has a beautiful coastline, a very cold ocean. We are surrounded to the north, obviously, by San Francisco, and to the south, San Jose, Silicon Valley, to our immediate south. So we're kind of between those two places. The private defender program is nothing new. The private defender program has been in business for 41 years. We started in February of 1969. And this gives me an opportunity to point something out right at the beginning and to provide a context for my suggestions and ideas and some of the things I make. We've had 41 years to refine it. So some of the suggestions I'm making, if it seems like it's daunting and that we can't do that, it took us a long time, particularly the last 11 years have been a real progress and growth and refinement of the way we do business. So it took 41 years to do it. It didn't happen overnight. We handle approximately 22,000 cases a year. We have 115 lawyers, all of whom are in private practice. They are all independent contractors. We have 36 investigators. We have a staff of about 13 people. So our ratio of lawyers to investigators is about 1 to 3, which is, in our view, an ideal ratio. The investigators, too, are, in fact, independent contractors, with the exception of the chief investigator, who is an employee. Employee of what? Be a good idea for me to tell you. The Private Defender Program is a program run by the San Mateo County Bar Association, as it has been for the last 41 years. And the Bar Association has an agreement with the county, which we are in the 5th year of a 5-year agreement right now, that provides for the funding and provides for a lot of other things that I'll talk about here and after. And that's been going on, again, for 41 years. The investigators are independent contractors. The lawyers are independent contractors. I am an employee of the San Mateo County Bar Association as the chief defender. There are 2 other attorney staff members. The assistant chief defender is Myra Weir. She's been on the job there for 4 years. Before that, she was a trial lawyer with serious experience. She was the first woman to ever be lead counsel in a death penalty case in San Mateo County. And then we have Jerry Hilliard, who's our managing attorney up in juvenile. So the Private Defender Program does it all. We are the primary defender. The lawyers are in private practice. We not only do criminal defense, we do juvenile delinquency, we do juvenile dependency, that's abused and neglected children and their parents. We do what we call Lanterman-Petrus-Short Act, which is mental health cases, people who are subject to involuntary confinement in mental institutions. And we do any other kind of case for which the counsel of public expense is provided by law. So we have that whole ballgame, and I'm trying to think what other things to tell you. I can tell you a little bit about the budget. Our budget for the last fiscal year was $16.5 million. In terms of the breakdown to how it was spent in general, and it's off the top of my head, generally there's about $11.4 million were spent in attorney's fees. There was approximately $1.8 million that was spent for investigation, and about $1.2 million of those dollars were spent for expert witnesses. And I'll talk about that a little further as we go along. So that's kind of the overview. And the 2 topics I'm talking about today are investigation and performance measurement. But let me talk about the effective use of investigation in general and our philosophy. Having an investigator for your case is not a luxury. It is essential. It is not indispensable for any case. Cannot do it on some cases. Any case that calls for an investigator with the Private Defender Program is appointed to, you get an investigator. That's all there is to it. An investigator is a tool. It's like asking a carpenter to build a house with no hammers and no saws. It's not a luxury. I mean, if nothing else, just the basic evidentiary and ethics practices that involve interviewing witnesses. For the lawyer to say, well, I pick up the phone and call the witness, and I said, okay, Johnny, what's the scoop? And then the witness got on the stand, the witness said something other than the scoop. How do you impeach that witness with their prior statements unless you've had an investigator interview that witness? I mean, that's kind of basic for lawyers, but for folks here who are funders and don't practice law, the lawyer can't take the stand during the trial and say, ladies and gentlemen of the jury, I called that guy on the phone and he told me something else. Can't do that. It doesn't work. That's not ethical. You'd have to have another lawyer come into the case and have that lawyer take the stand and testify. It is totally unworkable, and it's essential. And the other thing that makes lawyers essentials, and I'll emphasize this a little later, is that the investigators who work for us, the vast majority of them have extensive law enforcement careers in their background. They've retired for reasons that the California pension system makes desirable for them. They have tons of experience and training that was paid for by somebody else. And what they bring to the Private Defender Program and the lawyers is special skills and knowledge about how criminal cases are investigated, how they're handled. So if we get a lawyer who's been out of law school for a couple of years and give her a case and she says, I need an investigator, and she gets that investigator brings a lot more to that case than simply interviewing witnesses. They bring this is how it works, young lawyer. work with me, work together with me, and they can teach every lawyer a lot. And we'll talk more about training and all that shortly. So what are the criteria that the private defender program uses for requesting an investigator? The short answer is none. Anytime you have any kind of a case, whether it's a misdemeanor, it's a juvenile delinquency, a juvenile dependency, a felony, a murder, petty theft, any case that you request an investigator on, you get it automatically. Make the request, it's automatically yours in any kind of case. As Jim Levine mentioned a little earlier, there's no such thing, or shouldn't be any such thing as misdemeanor due process as opposed to felony due process, okay? A person's misdemeanor case is vital to them, it's essential to them, and they deserve due process for that petty theft or DUI case just as much as somebody who's charged with a felony. It's just crucial. So what kinds of cases have we been involved in? These are the different categories we use for our investigation division. We have investigators who are qualified for different levels of cases. Just to give you some example, in the fiscal year ended June 30th, 2010, we assigned out for investigation just shy of 1,400 cases. 1,382 cases were assigned out for investigation. 530 of those were felonies. 391 of them were misdemeanors, and 165 of them were juvenile. And then there's some miscellaneous things, gangs and special, Spanish speaking. We have investigators who speak Spanish, which is crucial in our part of the world. The number of clients who speak only Spanish in our county is growing by the day. They speak no English, and so the cost associated with all that and the importance of having an investigator is amplified because a lot of folks who speak only Spanish involved in criminal activity of some sort, the witnesses all speak only Spanish. So having investigators who are able to talk to those folks who know what they're doing is very, very important. So the question is, what investigator do I get? Who do I get? It is the policy of the private defender program that you get to choose the investigator you want to work with in a case, subject only to two things. Appropriate and available. And let me explain what that means. We have learned that having relationships built between attorneys and investigators is a very valuable thing. They understand each other, they know how they work, they feel comfortable giving each other advice, they feel comfortable sitting down and just talking about the ins and outs, they feel comfortable talking to the client together, which is another important component of having an investigator involved in a case. Appropriate means what the previous slide meant. If you are an investigator who is qualified to handle a homicide case, then that lawyer is an appropriate choice. In other words, a lawyer doing a homicide couldn't choose an investigator who was only qualified to do misdemeanors or lower level felonies. That would be not appropriate. And available means the process of case weighting and case loading applies to investigators just as much as it does to attorneys. That's why we have a chief investigator. If a lawyer says, I would like Joanne to work with me on this case, the investigator, and Joanne has cases that are lined up from here to New York City, Joanne will not be an appropriate available choice. So the chief investigator would contact the lawyer and say, listen, she's a great investigator, but her caseload is such that it'll affect her work, just like caseloads and work weighting, case weighting affects lawyers' work. So that's the job of the chief investigator. Picking your own is the rule rather than the exception, but the exception would be the chief investigator would have to step in and say that investigator's too busy. Now, what about timeliness? How long does it take to get an investigator? Well, we are very fortunate that there's good news and bad news about the electronic era. The bad news is, of course, you have 400 emails sitting on your desktop when you get home. When you get at the end of the day. And for me, in this time zone, when we ended at 5 o'clock yesterday, that meant I had 2 more working hours because my office was still open until 5. So that's the bad news. The good news is that our district attorney's office has been adapting to the electronic era with electronic discovery. And I understand that, and for the non-lawyers who are present. Discovery is the law enforcement version of the case. A police officer has, or officers have investigated a suspected crime. They've written reports. They have crime scene diagrams or whatever they have, depending on the nature of the case. And the obligation of the prosecutor is to turn that information over to the defense. How a case is handled by the defense very much depends on how timely that exchange of information takes place. And more, our district attorney's office is transmitting this discovery electronically. We make 2 trips to the DA's office, which is across the street from our main office, and we pick up whatever discovery is there. On the day the person is arraigned in court, we get it right now. So again, having a system where all you need to do is ask to get an investigator, that information is readily available and is ready for assignment with all the information we have up to that point in time. How long does it take to assign a case? We went through several examples before I flew out here with the chief investigator to take a look. Generally, about 2 hours. From the time of the request, which is sent electronically, to the time that investigator has been assigned and has the paperwork in his or her hands, is about 2 hours. That's about what it averages. Okay. The other thing about investigation and its importance is that, at least our philosophy, if what you want is a check the boxes request for discovery form, if you simply want to submit an investigation request that says, interview Johnny, interview Mary, take some pictures of the crime scene, and send it to me, that's really not going to accomplish much, in our view, for a client. The lawyer has to have spent the time understanding where they want to go with the case. They have to take a look at it. They have to say, sit down with the investigator, this is what I think happened, or this is what we believe happened, or can they prove this case? What are the strengths? What are the weaknesses? And all of which, again, points to the idea of having an experienced investigator who's been a police detective for years. So they take a look at the case, and the example of a young lawyer. A young lawyer gets to learn a lot by listening to an experienced investigator / formerly a police officer sit down and explain what's strong, what's weak, and where can we go with this case, where should this case go. So our philosophy is that a check-the-boxes approach simply marginalizes the expertise of investigators, and it is a team effort, attorney and investigator. Strategic spending. We are firm believers in strategic spending, and I know, again, there are not a lot of non-lawyers here, county commissioners, judges, other folks who are very involved in the criminal justice system, and there's no question that we're in difficult times. California is probably insolvent, more than on paper. It is a mess. It is a disaster, and I don't pretend to understand what kind of situation the state of Texas is in, but I can tell you California is worse than anything you've read. It's really a bad situation. So, when you're talking to funders about, well, we spent $1.8 million on investigation last year, and if you just listen to that off the top of your head, you say, well, that's a lot of money. I mean, why would you spend $1.8 million interviewing witnesses and doing crime scene diagrams, and why would you do that? What's the efficiency in that? Well, there's a lot of efficiency in it, and there's an old adage, I think it goes something like, you have to spend money to make money. And in the indigent defense business, at least in our county, we have learned in order to save money, you have to spend some money wisely. We have a new chief investigator named John Nannis in our county, and John came to me when he took over the job about 1.5 years ago, and he said, I see a critical need for some training. Can you give me a budget so I can train investigators? Now, be mindful of the fact that in the state of California, once you get your ticket from, I forget what it is, the Bureau of somebody or other in the state of California, you get a license to be a private investigator in California. Your education requirements for continuing education, 0, non-existent. You just cut a check every year to whatever bureau this is. I think it's the same bureau that licenses cosmeticians, I believe. I believe, there's no put down to anybody, but it's the same bureau. So you send them a check every year. They say, thank you very much. Here's your PI license, and go make a lot of money and cut us a check next year. So there's no requirements whatsoever. We decided to change that for a couple of reasons. To the best of my knowledge, we're the only indigent defense organization who has a mandatory training component. It's mandatory. It's not, gee, if you get a chance, there's a nice class for you to attend. This is mandatory. You need to know this, because there's nothing less efficient than somebody who doesn't know what they're doing, who's out burning hours and billing you for it, floundering about without any specific direction. The other thing we have done in terms of cost efficiency is regional training. Now, we are in a Bay Area that we're surrounded by some large counties. We have combined efforts with other public defender institutions in the Bay Area. The Alameda County Public Defender's Office, Diane Bellis is the chief defender. Mary Greenwood, who's the chief defender in the Santa Clara County. That's the one immediately south of us in which San Jose is located. We've combined efforts with them and sat down and found out what expertise we can share. So when the other counties said, we really need some training on robbery investigation, we have an expert, one of our investigators, has taught and still continues to teach at the police academy on how to investigate robberies. So we have 3 counties send all their investigators to sit down and have our investigator do a 4-hour training on robbery investigation. What did we charge the other counties? Absolutely nothing. What did they charge us when our investigators wanted to have a training on sex crime investigation put on by another county? They were all invited to all of the trainings. We share, and nobody charges anybody. And believe me, there's enough places, at least in California, for any kind of continuing legal education or continuing education that charge considerable sum of money to get that education. This is just spending money to save money. The other thing that collaboration is so important. I'm going to try to give you an example of what it means to know other defender organizations and know who knows what, and to make contact with them. We were more or less an island for a long time. We decided that was not only not smart, it was way not cost efficient. Example is, we had a case, a very, very serious case, where a young man was charged with a carjacking at gunpoint. Mom and dad and a couple of kids in the car, which in California could cost you most of the rest of your life in jail. It's a very, very serious crime, and they had, the police had arrested this fellow, had shown a lineup and all of that to the victims of the crime, who had positively identified our guy. They hook him and book him, and we get appointed to represent him. The client said, I didn't do this. Well, of course, I understand that. I've been doing this for 32 years, and you can't develop calluses. That's the most dangerous thing. The most frightening thing for an indigent defense representative, a criminal trial lawyer, is the factually innocent client. There's nothing more terrifying, because by the time a case gets to where it's going to be charged, where it is in fact charged, the state has convinced itself beyond a reasonable doubt, convince themselves that they can prove beyond a reasonable doubt that this person committed this particular crime. So by the time we get to the charging, we have a preliminary hearing, we're set for going to trial, the state has absolutely convinced itself it can prove this case and that this person did it. This is where collaboration came in. The defense, in part, was this fellow was in Mexico at the time. And if you've ever had any opportunity to try to do some investigation in a foreign country, I can assure you that it can be very, very difficult. We fortunately, in the Bay Area, the Mexican consulate in San Francisco area is wonderful. They are wonderful people. And this fellow had gone into Mexico. Frankly, I've forgotten where it was in Mexico. He said he was in Mexico. He had visited a particular doctor. He'd even been in a hospital there for some treatment, whatever. And so finding information. How do you get border crossing records? Well, you could spend 3 or 4 weeks on the phone, or you could put it out on a listserv of your fellow investigators in other counties and say, has anybody run across this? And an investigator for the Federal Public Defender's Office says, here's how it's done. Let me help you. That saved untold hours. We were able to get the Mexican government's cooperation. But of course, if you've ever dealt with Mexico, they have some quirks. We got them to say, yes, here's some documents, and here's official documents that this kid was here at this point in time and that point in time. But you know what? We still have to get the seal. Okay. The seal is something, it's almost like something out of the Middle Ages. They have the wax dripping and they go, plunk the ring on there. Well, they had all the signatures, but the seal was taking a while to come. And so while we're dealing with all this, I had been in contact with the lawyer to see how he was following up on what our investigators had already found that the lawyer, in my view, was too slow on the switch, and I removed him from the case and assigned somebody else. And we are at this point in time, probably today, the case will be dismissed. It was the wrong person, and a very serious case. And an unusual situation, we were able to tell them exactly who did it, because it was the guy's brother. But all that notwithstanding, that's the thing about eyewitness identification, as we all know. But the collaboration with other people is absolutely crucial, and investigation is absolutely crucial. This young man was looking at, I don't even know how I calculate the years on this. I mean, assault with a deadly weapon for all the people in the car, plus use of a gun in California will cost you a big chunk of time. Carjacking at South carries a big chunk of time. So this was a very serious case, and collaboration helped us a lot.